We're going to get us started, but just in time, thank you all for joining the Edley Center on Law and Democracy for today's discussion of political repression in American public law. I'm Catherine Lhamon, I'm Executive Director of the Edley Center, and I'm so delighted to welcome back home to Berkeley one of our faculty co-directors, Professor Jonathan Gould, who defected to NYU Law School, but is home where he belongs now today, and happily still affiliated with the Edley Center, so we're really lucky to still get to benefit from his expertise. And then also we'll be in conversation today with founding and current faculty co-director Daniel Farber, who's going to be in conversation also with Professor Gould. So our format for today will be Professor Gould talking about a new paper that he has about political repression, and then we'll have some commentary discussion back from Professor Farber, and we'll open for conversation and questions with all of you.
Thank you so much. It's really wonderful to be here. This very much feels like a homecoming, and the Edley Center was a labor of love, helping get it started with Dan, and now having Catherine on board to take it to great places. It's really wonderful to be here and to continue to be affiliated with the Edley Center. I see a couple of former students in the room, which makes it especially fun to be back at Berkeley, not to mention the warm weather that should never be taken for granted for those of you who spend time outside of the Bay. So I'm here today to talk. I'll talk for between 20 and 30 minutes about a new paper, Political Repression in American Public Law. The paper came out of our current moment for obvious reasons, and I will talk about our current moment, but was an effort a little bit to abstract away, to ask what are the broader features of the American legal order that make repression possible, impossible, more likely, less likely. The paper obviously comes from the normative standpoint that repression is bad, and we'll talk about that, but also is trying to do a kind of diagnostic of just as, like, what are the risk factors for various diseases, what are the legal risk factors for political repression? There may also be cultural, economic, other factors, but I'm going to focus on the risk factors. This is very much work in progress. There is a rough draft that exists in the world. If anyone wants to see it, send me a note. I'm happy to share. But also, I plan on continuing to revise. So questions, devastating objections are very much welcome, and they will definitely shape the paper. So to set the stage, it is not a surprise to anyone that democratic backsliding is a topic of conversation, a topic of concern across the Western democratic world, including, of course, the United States, for, I would say, in its most acute form for roughly the past 10 years, though obviously there are antecedents here and elsewhere. Democratic backsliding has many components, but one component of backsliding is political repression. You may ask, what is political repression? There's a lot of contestation in the literature on what the definition is. But a brief and I think useful back-of-the-envelope definition is government using state power to target political opponents for adverse treatment without legitimate policy reason. And note the without legitimate policy reason is doing a lot of work here. So let's say a Democratic president wants to make life more difficult for oil companies. That would not be political repression because there's a bona fide public policy reason relating to the green energy transition, as distinct from just wanting to punish people who vote with or give money to or affiliate with the other side. So too, if a Republican president did something anti-union, that would ordinarily not be political repression, because ordinarily there's a kind of political economic philosophy around free markets and corporate power that would justify that. So a lot of the kind of edge cases of is this repression or is this not are going to turn on, is there a bona fide reason? Is there a reason given? Do you think the reason given is legitimate versus pretextual? There are a lot of hard cases where you could say, well, this is arguably repression. I'm going to try to focus on the core cases in the talk, just for parsimony, but I'm also happy to talk about other examples or other more contestable cases as we go on. I have examples here of what I think of as core cases from history. I'll give more contemporary examples, but on the top left, some correspondence among White House staffers about Richard Nixon's enemies list. When you see the word enemies, that is a clue that repression may be going on. And then next to that, a picture of Senator Joseph McCarthy, who of course engaged in a project of trying to suss out communism in the US government, in Hollywood, and elsewhere, and engaged in tactics that many of us, I think, rightly associate with political repression. There are many possible levers of political repression, and I won't talk through each of these in detail, but I'll just emphasize that many different state powers could be used for political repression. So you could prosecute your political opponents. You could use regulatory power, say, to approve mergers for friendly news outlets and not approve mergers for unfriendly news outlets. You could use the taxing power to audit people you don't like. You could use control over public funding to try to withhold funds from people you don't like. You could condition other benefits. Think here about who gets a security clearance or who gets a Secret Service detail. So I think one of the challenges in thinking about the law of repression is it is basically the law of everything. That almost any state power used wrongly or in the wrong hands could be a tool of repression. There's a kind of libertarian answer to all this, saying, well, if everything up on the slide could be a tool of repression, we should just have less of all these things. And I think that's obviously unattractive because state power is important to secure public goods and health and safety and economic prosperity and civil rights and any number of other things. So the challenge is, how can you enable government to have all these powers, which in the aggregate can and often are, usually are, used for good, while also restricting the ways in which these powers and others may be used for repressive ends. So the question, as I kind of previewed at the jump, is what public law rules and institutions make political repression more or less likely? This is not a story about determinacy, it's a story about tendencies, in the same way that smoking makes cancer more likely, which is not to say every smoker gets cancer and every non-smoker does not, but there is a well-established correlation with decades of research. I'm trying to, with much less robust of a quantitative evidence base, say something similar about repression. What are the kind of the legal designs that will make repression easier versus harder? And it's fundamentally a question about legal and institutional design. So for example, one variable that bears on whether or not we have repression is the character of the people who hold public office. That's kind of critically important, but outside my scope. I'm going to think through institutional design, and you'll see in a minute most of this talk is organized around the three branches. So institutional design and legal mechanisms in Congress, in the executive branch, and in the courts. And I think this is part of a project more broadly to take seriously anti-repression as a public law value. It's not the only public law value, but if you think about your con law class or your ad law class, what are the kind of values that get talked about? Well, there's a kind of welfarist value of pursuing the public good. There are civil liberties values of protecting individual rights. There are values of efficient and effective government. There are values of democratic accountability and representation. And I just want to kind of add to that list, say that we ought to think of political repression as a value alongside those others. Hard questions come up about what happens when political anti-fighting repression potentially is in tension with some of those others. I'm going to talk about that a little at the very end. But the goal here is to kind of take seriously the idea of repression as a public law value. So the bottom line, I was given good advice when I was starting off teaching that a law talk is not a mystery novel and you should not save anything suspenseful for the end. So I'll give the bottom line now, which is law is profoundly limited in its ability to limit political repression in the contemporary United States. Part of this is for intrinsic reasons, that law, any system of law in any polity would have limits, and I'm going to talk about some of those. Part of it is for contingent reasons, features of our constitutional order that happen to be features of our constitutional order, say the way the courts have interpreted Article 2 of the Constitution, but are not kind of inherent to constitutionalism generally. That said, all is not lost. Meaningful reforms are possible, and at the end I'm going to briefly put a bunch of possible reforms on the table, and then we can talk about more in discussion and Q&A. So, quick survey, and again, I'll kind of march through the branches. So, executive branch safeguards against repression. First, you can have hurdles to agency policymaking. So think of these as veto points, things that make policymaking more difficult. Some of these are general, say a rule has to go through notice and comment, that's a transsubstantive requirement. But there are also more specific requirements that seek to rein in particular types of activities. So 3 examples I talked about in the paper that I'll briefly mention here are, one, if you're prosecuting, say, a sitting elected official, there are additional safeguards and additional approvals that you have to go through within the Department of Justice, the idea of which is these are weighty prosecutions that shouldn't be undertaken without sufficient vetting. Obviously, if the DOJ higher-ups are the ones initiating the prosecution, then these are going to be pretty weak constraints. But they're at least there, and they're kind of there in the spirit of seeking to create limits. So too, in the bottom right here, that if you're going to subpoena a journalist, there are a whole bunch of additional steps that need to be taken, whereas if you wanted to subpoena you or me, you wouldn't have to take those steps. Same idea. The IRS has communication rules saying the president and vice president cannot direct the IRS to audit anyone in particular. So it would be a violation of a statute for the president to call up the IRS commissioner and say, I don't like John Doe, I don't like Jane Doe, please audit them. Whether that would be constitutional under Article 2, that statute would be constitutional under Article 2, is a question that's never been adjudicated, but at least the statute is there. There are also special statutory procedures before funding cutoffs. So I mentioned funding cutoffs as one potential mechanism of repression. Not always. There can be bona fide legitimate policy reasons to engage in a funding cutoff. But because it's potentially a tool of repression, there are all these procedures that must be followed, and often, though not always, are followed. And on this, I would commend an excellent Edley Center white paper on the procedures involved in funding cutoffs and the ways in which those have not always been followed in recent years. So hurdles to agency policymaking are one big category. A second big category is the relationship between the president and agency leaders. That with some exceptions in American history, most notably Senator McCarthy, who was on the opening slide, often repression is directed from the executive branch or from the president. Certainly if we look cross-nationally, this idea of the strongman leader directing repression is much more common than repression being directed by a legislator, a judge, or a subnational official. So in that sense, we should care about the relationship between the president and agency leaders. The hypothesis would be if agency leaders are more tightly accountable to the president, our worries about repression go up. If agency leaders are more independent, our anxieties about repression go down. On that score, the jurisprudence that has, I was going to say emerging jurisprudence, but basically emerged jurisprudence on presidential removal power, we would think would all else equal make repression easier, in that there are agencies that have historically been independent, think the Securities and Exchange Commission or the Federal Trade Commission, where the courts are in the process of reading Article 2 to give the president greater authority over those agencies, which at the margin, again, not saying a dramatic effect, but at the margin would or could facilitate political repression. A similar story can be told about the relationship between agency leaders and civil servants, to the extent to which almost everything I mentioned on the earlier slide, funding cutoffs, prosecutions, IRS audits, when the rubber hits the road, you need civil servants to take part in these to do them efficiently. If civil servants are empowered to resist unjust or unlawful directives, then all else equal, you would see repression be more difficult. If civil servants were not empowered to resist, then political repression would all else equal be easier. There's obviously a very large body of law dating back to the Pendleton Act in the 19th century, dictating the protections that civil servants have. I would say, if I had to summarize it in a sentence, civil servants have significant but not infinite legal protection. This is obviously something that was much debated and litigated during the Doge cuts of last year. And on the upside, we have a civil service. There are legal protections. On the downside, those legal protections are not as strong as they might be in any number of respects. So kind of a mixed verdict here. Zooming out on these executive branch safeguards, there are some benefits and some limits that I really want to highlight. The benefits of the executive branch safeguards is their ex ante. That they are basically shaping the architecture in which government operates. So unlike some of the other safeguards I'm going to talk about later that require someone to act reactively, these are kind of ex ante shaping the atmosphere rather than ex post kind of limits or accountability mechanisms, which has real benefits. That the best repression is not repression that happens and is punished, but repression that never takes place in the first instance. So if these mechanisms can prevent repression from taking place in the first instance, that is obviously quite attractive. And there's not a need for external enforcement. So you don't have to ask what are the preferences or the incentives of courts or legislatures or others. They kind of work on their own accord. So that's, I think, the main benefit of these executive branch mechanisms. The limits are that they may be under-inclusive. So given, again, go back to the second slide, given that so many different powers of government could in theory and often in practice be put toward repressive ends, saying, okay, we're going to have rules about tax audits, that's fine. I'll target you not through a tax audit, but through some other lever of government power. There's a risk of under-inclusion of some of these mechanisms, and ultimately the rubber hits the road with external enforcement. So who's to say some of these architectural features won't be ignored? Well, someone, for my purposes, either Congress or the courts. You can imagine also protests in the streets or other kind of external, or markets or other kind of external forces of pressure. But absent any sort of external enforcement, some of these executive branch mechanisms may be weaker than they look. Pivoting now to congressional safeguards, and I'll be relatively brief in talking about Congress because unfortunately Congress has not been as helpful as one would want on some of these issues. But I think it's important to survey the range of tools that Congress plausibly has. One is legislation. if there are repressive things going on or repressive things that one worries might go on, Congress could pass a statute directly barring it, barring federal funds from being used for that particular initiative. And that has happened. I think in our moment of I started my career as a Congress scholar. I've since sprawled out into many other areas. But one of the kind of elevator pitches I always have when talking about Congress is in thinking about kind of the current despondency in public discourse about congressional abilities to remember it was not always that way. So for example, the restriction on the president directing audits came out of a statutory provision enacted in the 1970s, along with many other provisions in the 1970s limiting presidential power, some of which have had more staying power than others. And the reason for these provisions was very, very clear. It was as a repudiation of Richard Nixon and the abuses of Watergate and other conduct in office. So there is possible legislation. Obviously, it took Nixon's fall from grace. Nixon would not have signed these statutes. It took a combination of a Democratic president in Jimmy Carter, a Republican president in Gerald Ford, who was seeking distance from Nixon. So there need to be kind of changes in the political environment for legislation to happen, but at least could happen sometimes. The Senate confirmation power, I think the Kaj Patel confirmation hearings were an interesting case study on whether Congress would vote down a nominee out of concerns about repression. They didn't in the end, but it was a live question for I think longer than many thought it would. And certainly if there were to be a Democratic Senate and a Republican president or a Republican Senate and a Democratic president, confirmation power would be much more robust as a counterweight to the president. It's an interesting thing. We haven't seen that the last several presidents, Obama, Trump, Biden, Trump, all came in with Senate majorities in their first year in office. They were all able to get kind of the initial cabinet that they wanted. If we were to get a president with an opposite party Senate in year one, I think it would be really interesting in our age of polarization. Every cabinet member would plausibly be a fight, which wasn't true in decades past in ages of lower polarization. Congressional oversight, both House and Senate, committees have subpoena power, they can gain access to documents, they can subpoena witnesses. This can be used for many, many ends, many good, many less good, but just for our purposes, this is one tool that if there's anxiety about agency X engaging in repressive activities, and a congressional committee wants to look into that, there's enormous leverage there on the part of the committee. And then finally, impeachment, which kind of lurks in the background and will very rarely be relevant, but in extreme cases could be. So the benefits and limits of congressional safeguards, these I think are fairly obvious. The benefits, this is kind of Madisonian checks and balances at its finest. If the executive is doing bad things, Congress can step in to check them. Congress can impose real costs through the power of the purse, through the confirmation power, in theory through impeachment. That Congress can impose real costs on the president, mainly through non-legislative means, but also through legislative means. If the president really wants to pass Bill X, and Congress says we're not going to pass Bill X unless we get the following guarantees with respect to repression, that could be a really powerful force. And Congress can react to real world events. So let's say some new mode of political repression were to be innovated, Congress could respond to that in real time. So those are the benefits. The limits are fairly obvious, that in an age of very, very high polarization, and the dynamics in Congress being one party defending the president and the other party seeking to undermine the president in almost every high-profile circumstance, with very rare exception. Under conditions of united government, you are not going to get meaningful checks on repression or much else through Congress. Even in conditions of divided government, you're not going to get legislation. So even if the White House is controlled by one party and Congress is controlled by the other, and the House and Senate come together to pass an anti-repression bill, the president could just veto it, and no single party has had a veto-proof majority in a long, long time. So polarization and presidential power, including but not limited to the veto, are the main limits of these congressional safeguards. Finally, let's talk about judicial safeguards. One obvious one is the First Amendment. That if you are targeting people because they are Democrats, or because they are Republicans, or because they said X, Y, Z about whether or not the 2020 election was stolen, that's a First Amendment protected claim, and it seems kind of very straightforward black letter law that people cannot be punished for their political speech. There's good precedent on this, and the case of targeting of law firms for a variety of reasons, but at least some of those reasons involve First Amendment protected reasons. Speech made by the law firms, questions of who the law firms were hiring, including people who've been critical of President Trump, the types of pro bono and other cases the law firms are taking on, all there's First Amendment bases for them. Many law firms were targeted with executive orders for adverse treatment. 4 of those law firms sued, Jenner, Wilmer, Covington, and Perkins. All 4 of those law firms won. So that's a case, I think, at least on the surface, of the First Amendment doing exactly what it's supposed to do. There was an effort at political repression, some firms sued, the courts heard the case, the courts found for the firms, and the firms got their injunctive remedy. So that's kind of a happy story, but there are also some problems here. The first of which is, what is the incentive to challenge? These firms challenged, but of course there were other firms that didn't, and there were 9 firms, some targeted, some not targeted, that cut deals with the administration. The incentives to challenge are complicated, having to do with the nature of the law firm's book of business and what are their client incentives, what other business do their clients have before the government, and what their clients might be afraid of. It is telling that all 4 of these firms have quite large litigation practices. Firms with larger M&A practices responded differently. So there's kind of questions about incentive to challenge, both in this case and potentially in other cases as well. There are questions about chill, that you might think even though these law firms won their cases, this will change how these or other law firms go about their business to avoid being targeted in the future. And there are issues of proof. And there will almost, or for almost any repressive action, there will be a non-repressive justification that could be given. If you are lucky, the person doing the repression says out loud in a speech or on social media what their real motives are. But if they are ever so slightly more savvy, it can be really hard to prove the repressive motive is the relevant one, the predominant one, the motivating one, when there's a kind of non-repressive motive that could be given. So you've got these incentive to challenge problem, the chill problem, the issue of proof problem. And then there's also kind of a frontier question around jawboning. So this is a classic case, including law firm cases, government seeks to actually impose a harm on a party, and then the party has a First Amendment case. The jawboning case is not as directive as that, is kind of a wink and a nod, can involve a third party, can involve saying, hey, social media company, we want you to elevate these posts or put these posts down, take these posts down. So you might be talking about the kind of speech rights not only of the targeted party, but of third parties. There have been 2 Supreme Court cases on jawboning lately. One in which the plaintiffs won on the merits, one in which the plaintiffs lost but on standing rather than on the merits. And I think this kind of emergent law of jawboning is relevant to repression as well as to many other issues. Next we have administrative law litigation. So you might think, I mean, any of you who've taken administrative law know that actions that are not rational or they're taken for a reason not permitted by statute can be challenged on arbitrary and capricious grounds. That is, in theory, a really good lever for challenging political repression, and it can be effective. So I think the funding cutoff cases are interesting cases. Some may be repression, some may not be. I don't want to get into all the funding cutoff cases. But the fact is, there have been a lot of cases where under administrative law principles, funding has been restored. So that seems to show the promise. That said, administrative law has several notable limits, one of which is deference to agency enforcement choices. So for an agency to say, I'm targeting A but not B, when potentially A and B are both violators, is very much the subject of deference under long-standing administrative law principles. And that sort of makes sense, that you don't want the highway patrol officer to be required by law to pull over everyone who's speeding. That you might want some discretion. They can pull over people who are speeding egregiously, or people who are they can pull over every 10th car if they want to try to create a measure of deterrence. That you don't want to police enforcement too closely because there can be perfectly valid and in fact important reasons for enforcement discretion. But also if enforcement discretion is used in a way to target political opponents, that deference to enforcement choices can be a limit. A second limit is the APA gives you a cause of action when there is a final agency action, but if the agency is making threats or kind of saber rattling, but there isn't a final action, then the APA is a much less viable tool. And some issues are just outright non-reviewable. So with very few exceptions, I talked about a little bit in the paper, I threw a Politico article up here about revocations of security clearances, seemingly for people who the president just did not like, or had worked for his predecessor, or had worked for him, and then he had a change of heart. And there's a long-standing case law in the DC Circuit that individual security clearance determinations are basically non-reviewable. Case leaves a little bit of wiggle room, potentially in very narrow circumstances, but to a first approximation are non-reviewable. And of course, if it's non-reviewable, administrative law can't really help you. There's also selective prosecution claims, and there are related doctrines around vindictive prosecution and malicious prosecution. But this is the idea that you are being targeted because of who you are, your political activities, your political speech. Here I have Tish James, the Attorney General of New York, and Jim Comey, the former director of the FBI, both of whom were prosecuted in prosecutions that were widely understood to stem from the animus that the president had toward the two of them individually because of shared history that those of you who read the newspapers will be well familiar with. Selective prosecution claims can succeed, but there is an extremely high bar. That if you read the case on selective prosecution claims, the courts leave the door open, but all the language is in the most extreme circumstances, in the most egregious circumstances, that they are not going to be useful in the vast majority of cases. There's also a question of comparator group. So the classic selective prosecution claim is, I was speeding and you went after me, but look at these 10 other people who were speeding and you didn't go after them. So you've got a comparator, namely the other people. Who's the comparator to Tish James? Who's the comparator to Jim Comey? That when you have people who are in positions of high office, who are kind of potentially have idiosyncratic facts, it's harder to find the comparator with which to kind of make out the doctrinal claim. I'll note that both of these cases, which I had kind of high hopes could be the selective prosecution examples for the paper, ended with victory for the criminal defendants, but because of arguments involving the Appointments Clause and the ways in which the US attorneys were not lawfully exercising their power, so the courts didn't reach the selective prosecution claims. Finally, there's this idea of the presumption of regularity, which is the idea it is a bit of a moving target. There's a law review article that gives more than a dozen different things that the presumption has meant over the years, and I will not go through all of them. But the basic idea is we assume the government is acting in normal and lawful ways most of the time. And we don't dig too far under the surface, we don't peer too much under the hood, because we assume there's kind of regularity in how government is carrying out its business. There has been the presumption of regularity, obviously, in the face of an administration engaging in political repression, will make litigation against that repression more difficult. There's been some pullback on the presumption recently. It's tough to say exactly what the presumption looks like, because the judicial language is all over the place and mostly in the lower courts. But Just Security's been tracking the ways in which it's been talked about. I think it's pretty persuasively showed that the presumption is weaker than it was even a decade ago. Again, benefits and limits of judicial safeguards. Benefits initiated by private parties. So neither the stuff within the executive branch or within Congress that I've talked about empower the target of repression at all to do anything. Judicial safeguards do. The target can, if they're a criminal defendant, assert defenses. If they want to be a plaintiff, they can sue and seek to assert themselves in court. It's targeted to a particular repressive act that we don't have to think structurally or generally. We can just say, this prosecution, this tax audit, this funding cutoff are unlawful, and here's why. So you can have these very fact-specific arguments. And they're a backstop if other checks fail. So even in kind of a hypothetical world where the internal executive branch checks were maximally effective, were the best they could possibly be, they might stop 99% of repressive attempts. They would probably not stop 100%. So judicial safeguards provide a sort of backstop to that. That said, there are important limits. They are reliant on private parties, which I said a moment ago was a benefit, but is also a limit in that what are the incentives of private parties? Will the private parties be incentivized to sue? And the law firm case is a good example there. There are evidentiary issues, which I again talked about, that often there will be a kind of facially plausible non-repressive reason for a repressive act, and getting discovery on, say, internal executive branch deliberation can be really hard. There are all sorts of privileges involved there. So there are evidentiary issues as well. There can be insufficient remedies. What does it mean to be made whole? Even if you get some cash or an injunction, you might not be made fully whole. And finally, there's the problem of chill, that others watching, other individuals or firms or institutions watching what went down might feel chilled. So stepping back a little bit, I'll be very brief on this slide. So we can think of these kind of mechanisms in a few different ways. We think about the difference between ex ante and ex post mechanisms. So this is where ex ante mechanisms are the executive branch stuff and legislation that exists kind of before the fact. Ex post mechanisms are congressional hearings, impeachment, any litigation, stuff that happens after the fact. You can think about mechanisms that are general versus targeted. You can think about those that are reliant on partisan politics, say looking to Congress, versus those that are more insulated from partisan politics, say empowering civil servants. And we can think about trade-offs with different other values. So a government that could do nothing could also not engage in repression, but would be a bad government because we value effective government that solves public problems. So we have these kind of trade-offs, and in the paper I talk about each of these kind of dimensions of the problem. And finally, toward reform, and I'll not say too much about these now, but just note there are a whole range of things that can be done at the level of kind of tinkering within the executive branch, within Congress, within how we do litigation. And I'll keep this slide up in case anyone wants to ask about any parts of these, but there are a lot of things that could be done. I am not in this paper proposing radical changes in the structure of government. I kind of take as fixed that we are a presidential, not a parliamentary system, that we are a federal system. Kind of I take as fixed some of the big picture things and ask what are the kind of mid-level reforms that could be really powerful. And the verdict of the paper is kind of, I don't know if it's cautious optimism or cautious pessimism, but it's certainly cautious. That kind of law is structured in a way that makes repression possible and that makes acting against repression hard. But also there are levers and there are meaningful ways in which repression can be prevented and pushed back against. So this is where I'll end. I'll keep the reform slide up if anyone wants to chat about it. Really grateful to Professor Farber for what I anticipate will be incisive and helpful comments, to Catherine for the invitation, and to all of you, and hope we can continue the conversation.
Well, that was terrific, which won't surprise any of you who remember Professor Gould from his time here, either within the classroom or as a speaker. I think the paper, which was the basis of the talk, makes a major contribution by pulling together all the different institutional aspects that are involved in repression and the ways in which those institutions may do a better job or a worse job in that setting. You know, as far as I know, no one's done that before. And once you start thinking about the problem in that kind of broad way, I think it kind of changes what you think about in terms of possible solutions and, you know, whether you're cautiously optimistic or pessimistic or, you know, whatever. The topic certainly couldn't be more important. I think just about every day there's more news relating to repression. So, like just recently, we saw a Department of Justice subpoena against the Federal Reserve Bank that was very unusually quashed by the district judge, who said that it was abusive because they really had no reason to suspect criminal misconduct, and it was motivated by a desire to retaliate for policy decisions they didn't like. Another example, I think it counts as repression, is the classification of Anthropic as a national security supply chain risk on the basis that they were too woke in opposing things like mass surveillance and killer robots. Now again, there's, well actually I don't think there's any statutory justification for classifying them as a national security risk. You could argue that there is some kind of policy justification in that these decisions should be made by the government, not by companies. But it's, you know, given the amount of overreaction, it's pretty clear that it's because they were not bending the knee. And therefore, I think it does count as repression. And that's just within the last couple of days. So I want to keep my remarks short. So I'm just going to talk about two things. They're not really criticisms. I don't have much I quarrel with. And to the extent I do, they're sort of like footnote things. But I want to talk about some areas where I think you could maybe build on this analysis to think about some other aspects of repression. So the first one, which is partly at least about the limits of the institutional analysis, but you know, that actually is a little ambiguous. So, but you know, the real question is, okay, we've talked about these various things that can check repression, but what about us, right? none of us, you know, some people in the room work for the state of California, but none of us is a government official, certainly not a federal official. Does that mean we just have to sit by and watch while these more august institutions take effect? And that's true to some extent. But I think there's something, I guess you could call popular anti-repressionism, or something like that, if you wanted to be fancy. But it's really about the way the public can make its voice heard, apart from voting, which I'm putting aside. And we've seen some important examples of this. I mean, I think of all the pushback to potential authoritarianism, maybe the single most effective thing hasn't been done by the courts. It was done by the people of Minneapolis, you know, who under quite adverse winter conditions, which having lived there I can say were not unusual, you know, got out there, demonstrated when it was 10 below, showed up every day to witness what the government was doing and take photos and put them online, and exercised a very significant check that has resulted in the government pulling back considerably on its actions. So that's one example. Another example, and this is sort of, you could view this as being institutional in a way, and that's the extraordinary behavior of grand juries who have refused to indict in many of the significant repression cases. I say extraordinary because the tradition, if you haven't heard this line before, is that a good prosecutor can get a grand jury to indict a ham sandwich. Right? Grand juries are considered to be basically just tools of the prosecutor most of the time, but not this time, not in a number of important cases. So I guess that's an institution because the grand jury is an institution, but it's also the public having a voice. We haven't gotten to the point of actual criminal trials in these repression cases against people like Comey, but I think the jury becomes an important factor at that stage. Now, on the one hand, to get to that stage, the defendant has to go through a lot of risk, pain, and expense. On the other hand, losing at trial when the jury comes back in favor of the defendant in some ways would be much worse for the administration than having the courts dismiss the cases. Because a jury trial of somebody like Comey or Letitia James is going to be a very high-profile public event with, you know, sort of wall-to-wall coverage on cable and, you know, et cetera, et cetera, et cetera, and then having the jury come back and saying, no, government loses would really be an embarrassment. So I think this highlights a couple of things. One is, I think the First Amendment is not only important in the sort of protecting the targets of the government, but also in protecting the right of the public to get out there, to demonstrate, to post those pictures online, to take the pictures, to, you know, talk to reporters, et cetera, that we saw in Minneapolis. So vigorous enforcement of that part of the First Amendment could be really important. In addition, I think we could see some implications for grand juries. I don't think we want a grand jury that's going to throw out half the cases that are brought by good prosecutors, but we're at the other extreme. And it seems to me it would make sense to explore some ways of making the grand jury a little more of an active participant. I mean, we take it for granted if a grand jury returns an indictment, there's probable cause, but we don't have any real reason to believe that grand juries are making those distinctions if they always indict. And so I think that there are things that could be done. For example, they could be given access to independent counsel rather than having to depend on the prosecutor for all their legal advice. I think there's some things that could be done there. Maybe with juries, but there's been a lot of discussion of like jury reform issues, and I don't have anything to say about that. Okay. Now, my second point, which also is, I think, a friendly amendment. Well, I'm sure it's a friendly amendment.
I've known Dan for many years. He's always been friendly.
Now, if you don't show me the baby pictures, that could change things. So one of the interesting features of the Trump administration is that they're very open about striking at opponents. And I think one way of looking at that is the one that John just did of saying, well, maybe they're not savvy enough. But I don't think that's quite right. I think they are savvy, but they're playing a different game. And this is maybe an unfair analogy, but there were a few years ago, where a couple of defectors who were living in the UK were killed from Russia were killed using radioactive polonium, which is kind of a GRU trademark. Well, they didn't have to do it that way, right? I mean, doing it with polonium was equivalent to leaving Putin's picture on the table when you got them. They could have done it more subtly, something, a car accident or something like that. It wasn't because they're not savvy, it's because they wanted to communicate a message. And there are really two messages. One is, we want everyone to know that we nailed these guys because they crossed us. And the other message is, we are powerful enough that we don't have to be covert. We can openly kill our opponents and get away with it. So there's a message about strength. And on a thankfully less drastic level, I think that's what we're seeing with some of the executive orders and social media posts, et cetera. Right? They're communicating, they want everyone to know, no, we're not going after these law firms because we investigated them and they were doing something that was different than other law firms. We're going after them because they represented Democrats and they represented causes we don't like in pro bono cases. And again, that has two messages. One is, watch it because you could be next. And the other one is, and we don't even have to hide it. So that, I think, has a lot of advantages. It does make the First Amendment cases a lot easier, right? So the downside is you're going to lose in court more often, but even if, maybe you won't because you'll get the right judges, and even if you win all the cases in court, you can still have a real chilling effect on everybody else, which is what we've seen with law firms. Not just the ones who signed deals with the administration, but the ones who didn't even wait to start cutting back their pro bono practices and doing other things. I think that's really important, and I think it also goes to a somewhat larger point that I think could be a useful addition, maybe, and that's about the presumption of regularity, right? So if we permanently, if we have, we could have two options. One, we keep the presumption of regularity in full force and we let them get away with stuff. Or two, we permanently weaken it and then we hinder future administrations. But there is a third option in various forms, which is an on and off switch, or really more of a dial, I suppose, like a rheostat, where we say, we're going to keep the presumption of regularity, but you can lose it. You can lose the benefit of that presumption. Now, if we just say, you lose it if we don't trust you, that's obviously no good. That's just saying, if you're from the other party, you don't have to have the presumption of regularity. You need to have some objective basis, I think, to make that switch work in a way that's sort of reasonably objective. But we have seen courts doing that, right, where they point to the stuff that's actually in the executive orders or the way various other parties have been treated more favorably than the opponents, et cetera, et cetera. So that's objective. In another setting, we've seen them relying on experience with the Justice Department, right? I mean, the Justice Department used to have this stellar reputation, not for always being right, but for always being professional and competent. so that if they told you something about the facts, if they said something about the law, you could trust them. And there have been a substantial number of judges of both parties who have said, no, we can no longer trust these guys. Or we can't trust the government to obey court orders, as the judge said recently, with a list of 200 orders, right? So if you have objective evidence like that, you can have a toggle switch off and on for the presumption of regularity. And that seems more attractive if you can make it work, because that way you're not permanently hampering the government and the executive branch forever. Right. It's just that they have to earn it in the future. So I know there are going to be a lot of questions, and I already have run 3 or 4 minutes longer than I planned, so I'm going to stop right there and turn it back to you.
Great. Can I take 10 seconds to respond? Great. Yeah, so there's much to say about all this, and my main response is yes and thank you, but I'll say a couple of things of greater substance that I think are all additive rather than in tension with anything that Professor Farber said. The first of which is on this question of what about the public. The answer is like yes, absolutely, place for the public, place for protests, place for voting, place for other sorts of civic action. Did not mean to minimize any of that. That is not my field, but there's obviously a great deal of work by political scientists and social movement scholars and others on precisely this point. I guess the only thing I would say by way of addition that I think is talked about less is the relationship between kind of mass and elite politics. And it can go 2 ways. That if there is a mass protest, that might encourage Congress to look into something. And if there's litigation, that might reveal facts that lead to protests and actions on the ground. So these kind of the from below and from above can be mutually reinforcing and complementary in the best of times. But also sometimes you have only from below and only from above, and either of those can be effective and are quite important. Definitely yes to grand juries, definitely yes to petite juries and the possibility of an acquittal or even a jury nullification. I think both of those are good examples of the intersection of structure, which is to say we have a grand jury, which is not an intrinsic structural choice, but is one that was made a long time ago and has persisted. But 2, what are the character of the citizenry and how do people think about these issues and who ends up on the grand juries? That's a good example of kind of a design choice from above and popular issues from below coming together. Openness is a sign of strength, seeking to send a message, seeking to deter others, definitely. And it's totally possible, I won't speak to this administration or any other, but if one was trying to be savvy, one would recognize that being open has benefits on the signaling side and costs on the litigation side, and would want to think about the relative strength of each of those in any circumstance. Presumption of regularity, yes, definitely. There's a classic article on kind of realism and formalism in public law, and I tend toward 2/3 of the way toward the more realist side, and I think this is kind of a form of realism, that the presumption of regularity is not always or never available, but is available when earned, which doesn't mean excessive granularity. It doesn't mean, like, this AUSA I think is really sharp, this AUSA I think is less sharp, so I'm going to treat them differently, but might be a kind of a much higher level of granularity that, like, this Attorney General has earned the trust of the DC Circuit and this one hasn't, I think is a kind of more plausible, kind of higher order of generality way of putting it. But yeah, fundamentally all quite helpful, and I'm sure we'll keep talking and want to open things up.
Great. Go ahead.
Question?
Yeah.
First of all, thank you so much, Professor Gould.
Thank you.
Farber. Yeah, I'm really looking forward to the paper. And my question is, the pattern that I repeatedly observe from this administration's acts is refashioning of typically domestic issues into national security issues. And I think that's relevant in the context of political repression, because we see the case of Anthropic, as Professor Farber mentioned, and also the designation of individuals like protesters as terrorist individuals, like Antifa, that kind of rhetorics. So, and we know that the courts has been really deferential to the executives when there's this magic word, national security, and also many statutes give a lot of deference to the president's individual determination when it comes to the security issues. So I was just curious whether there's a safeguard, or there should be a safeguard against such like rebranding of domestic issues into like, national security ones?
Yeah, I think you're right to notice the phenomenon. I think it is not a new phenomenon. And I think the deference, by and large, is warranted. That if the President and Attorney General and FBI Director say that X is a national security threat, we ought not be willy-nilly in throwing this out. And I suspect some of you will go on to clerk someday, and the idea that a federal judge with no national security experience and 3 clerks who got great grades at Berkeley Law School are the ones to make that determination rather than the FBI is something that should give us pause. So I think the deference in general has many benefits, and I don't want to say like throw out the deference, but you're right that it absolutely can be abused, and there are real world examples of it having been abused. So then what do we do? I think I am intrigued by a move that the courts made, I think in the tariffs case, of like avoiding that issue. So the tariffs case was not, there was an emergency power question. And you could have imagined a case where the Supreme Court either said, yes, the president's right, this is an emergency, or no, the president's wrong, this is not an emergency. I think the case for it not being an emergency is pretty strong. The balance of trade has been what it has been for decades. I mean, the emergency implies something kind of temporarily emergent, which the trade issue is not. But nonetheless, you could have imagined the court really taking on the emergency power issue, and they didn't. That was conspicuously absent. What they did do was invoke the major questions doctrine to narrow presidential power. So that is what I would suspect you would see from federal judges in the face of overreach on classifying things as national security that ought not be. I think a pretty good approach is we don't want to defer, because that creates one set of problems. We don't want to scrutinize too harshly, because that creates another set of problems. So we're going to kind of use a backdoor and find a different means of narrowing executive power. I thought that was actually kind of, I may write this up, kind of an elegant feature of the tariffs opinion, which there's a lot else to say about, both good and bad. But I think you're right to put your finger on a dilemma, and I think it will be attractive to at least some courts to try to circumvent that dilemma. It's a great question. Thank you.
So after the grants pass decision, a bunch of organizations in the Bay Area that had an amicus brief for the grants pass, they got put on this watch list about their IRS status. And it was a think tank, but I was wondering, like, how does this apply to the administration going after nonprofits, tax status?
Yeah, absolutely applies. I mean, at the very beginning, like one of the potential tools of political repression is use of the taxing authorities. This was done in a really egregious way by the Nixon administration. There have been intermittent allegations of this. I think each of the last 5 presidents has been accused of weaponizing the IRS. Some of those allegations have had more credibility than others, but this is a persistent trope, and there have been Inspector General reports, and sometimes this is kind of a well-known tactic. I'll note it's also a quite well-known tactic in other nations that are considerably further down the backsliding process than we are. This is in many kind of democracies sliding toward competitive authoritarianism. Tax targeting, audits, tax penalties of one's political opponents are quite common. In terms of what can be done about it, I would kind of fall back on the various types of mechanisms that I talked about. That there are ex-ante features, so some types of structural independence for the IRS, especially with regard to kind of adjudicatory decisions of who to audit. I think it's really important that those be insulated from political decision makers, because the temptation to audit your opponents might be just too high. So I think that independence is really important, maybe in the crosshairs of Article 2 jurisprudence, which is a point of real worry. But that would be my kind of first line of defense. The second line of defense would be the First Amendment. The issue there is it's really hard, because if, let's say, you run a liberal nonprofit and you get audited, maybe that's because you were targeted, or maybe that's because just the computer selected you and we all got audited from time to time through random and totally benign means. And it would take a fair amount of discovery to figure out what was what, but getting to discovery requires pleading, but getting past pleading requires plausibility, and you're just kind of stuck. So that's a really hard issue. If there's a watch list that makes it easier in some ways, I've not thought about the grants pass amici, this is the first time I'm thinking about it, but my instinct is, if there's a watch list that makes it easier in one respect and harder in another. Makes it easier in the fact that there's less uncertainty about what's going on. That if the amici in a high-profile case get put on a watch list, that's kind of publicly putting up in lights that this is not just the computer spit out your name for an audit. Thing that makes it harder, and this is where me not being a tax scholar is a bit of an encumbrance, is a watch list any sort of final order that would lead to APA, that could lead to APA litigation? Is there actually harm to being on a watch list if it's just being on the list and nothing else happens? You have to wait to get audited or otherwise targeted beyond just being on the list. And I would have to get a bunch more information, but that would be another complication to think through.
Would you say that the tools you've highlighted serve as a check within each branch, just because each of these branches is vulnerable to serving also as tools of repression themselves? So is what you've highlighted a way internally to prevent that from happening, or is it more of a tool for, I don't know, like external use?
Yeah, the way I say this more explicitly in the paper, and probably should have in the talk, the way I think about these checks are basically as checks on the executive. So checks on the executive within the executive, checks on the executive from Congress, checks on the executive from courts. To be sure, there could be repression initiated from outside of the executive, and I think McCarthyism is a good example. If you look cross-nationally, the vast majority of repression in kind of backsliding democracies is from within the executive, for a fairly obvious reason, that legislatures face big collective action problems. Also, legislatures are typically, not always, but typically in the business of making general pronouncements, not saying, I'm going to audit you, but not you. And courts are in a reactive posture. The courts, I think the role of courts in this story is that they will either push back or not push back, but they are rarely going to be the ones. I mean, if the Chief Justice woke up in the morning and said, I want to engage in political repression, it's not clear where he would start. That his role is kind of, from a reactive posture, the executive branch does things and he can give a thumbs up or thumbs down. So the orientation of all the checks in the paper, which I think tracks kind of the risks in reality, is around checking the executive. Thank you for clarifying. Yeah.
I'm curious what certain structural like separation of powers issues have like played in your consideration of these tools. Like I'm thinking about like the non-delegation doctrine and its potential revival. I'm curious if we're thinking about like the judiciary's role as being a thumbs up or thumbs down on executive aggrandizement, that issues like that could potentially, like regardless of the number of like theoretical checks that exist in other branches, like whether we may be hamstringing ourselves here for, yeah, like I guess I'm wondering if you thought about things like that in your paper.
Yeah, it's a great question. I think I have two responses. Let's make a note here. So, non-delegation in particular, I think even those who we can think of as non-delegation hawks, so people like Justice Gorsuch, who really want a more robust non-delegation doctrine to reign in Congress, are still okay, and I think need to be okay, with the executive branch making adjudicative or enforcement decisions. That they're still okay with the executive branch saying, I'm going to audit you but not you, I'm going to prosecute you but not you, making those kind of case-by-case decisions, and much of political repression is those case-by-case decisions. So non-delegation is about the delegation of what? Of legislative power. So I think a revived non-delegation clause would have many effects. I personally think most of them negative, but for reasons not having to do with repression, on, say, rulemaking, on, say, the EPA, on other agencies that do a lot of rulemaking, but it's not obvious to me how much it would bear on this. I think it's somewhat orthogonal. And that, I think, gets to a broader issue with the paper that I'll flag. But, like, in some ways, like, when I've talked about this paper with students a couple times, like, it's a fun paper to talk about with students. It's sort of an issue spotter. It's sort of like you take your con law syllabus, you take your ad law syllabus, and you like look at each issue through the lens of political repression and see what there is to be said. That said, the issues that are most important and cutting edge and controversial in con law, ad law, and the issues that are most at the forefront here are just very different issues. So for example, everyone agrees, even kind of anti-unitary executive folks, that the president has to be able to fire the attorney general. That the Attorney General is exercising kind of core prosecutorial power, which is core executive power, going back to the beginning of the Republic and before. And we can argue about should the president be able to fire an SEC commissioner or the Fed chair, and like that's what's going to be litigated. But the issue that most matters for repression is the Attorney General, the FBI director, is some of these officials who are obviously under Article 2 subject to presidential control. So there's a bit of a disconnect. I don't think it makes either project more interesting and more or less interesting. There's a bit of a disconnect between like what are the cutting edge issues and most important things on repression, and what are the cutting edge issues and most important things on public law writ large.
And with that, I will have to thank you.
Thank you all.